I'm calling to order a code enforcement hearing in the city of Cape Canaveral. Today's date is August 27, 2024. My name is Richard Geller. I'm special magistrate appointed by the City Council to hear code enforcement cases pursuant to Article 6 of the City Code and Florida Statutes Chapter 162. This is a quasi-judicial evidentiary hearing. The burden of proof is upon the city to show by a preponderance of the evidence that a code violation exists. In other words, I will determine from the evidence presented to me this evening whether it is more likely than not that a violation has occurred. The alleged violator will have an opportunity to submit any rebuttal or exculpatory evidence, including testimony. At my discretion, I may allow a member of the public with relevant personal knowledge to testify, even if not called by either the city or the responding party, and anyone who would like to testify should so indicate. Upon request, an alleged violator may ask relevant and material questions of any city witness, and the city may ask relevant and material questions of any witness for a responding party. I may exclude evidence that I deem irrelevant, material, or repetitious. In determining the amount of any fine, I will consider the gravity of the violation, any actions taken to correct the violation, and any prior violations committed by the respondent. Under the City Code and Florida statutes, I may assess and order the payment of fines of up to $250 per day per violation for a first violation and up to $500 per day per violation for repeat violations. In an extreme case, I could order the imposition of a $5,000 fine for damage that is irreparable or irreversible. Excuse me. I may also award the cost of any repairs made by the city. At the conclusion of the hearing, I will issue findings of fact and conclusions of law based on the evidence of record, and I will also issue an order that will be both here on the bench and in writing, which I'll endeavor to do tomorrow. The city will record a certified copy of an order imposing a fine, which will become a lien against the land where the violation is deemed to have occurred, as well as any other real or personal property owned by the violator. Any order I issue may be appealed by any party to the Circuit Court for Brevard County within 30 days. It is the responsibility of the appealing party to obtain a record of these proceedings. An appeal is limited to the record that is presented to me. The city's agenda packet will be administratively accepted into evidence as City's Exhibit 1, and its PowerPoint slides, which I have a printed copy of for this evening, will be administratively marked as Exhibit 2. I have signed and approved of the minutes from May 28th, 2024, and I've given them to our secretary, Ms. Roth. Our next meeting will be September 24th, 2024. And Mr. Palmer, you may be the only witness here this evening. Could I just swear you in evidence? Swear you in, please. Do you swear that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you, sir. So the first case is 23-391, alleging violations of 34-96 and 34-97 of the City Code, and I'll let you proceed, sir.
Okay, I'm Brian Palmer, Deputy Director, CED Code Enforcement Manager. This is case number 23-391, Jackson Residential Land Trust, number 406. Next slide will show the address at 406 Jackson Avenue. The legal is on your slide there, and along with the partial ID. The violation is for duties and responsibility for maintenance.
All right, and the parcel ID comes from the official records of Brevard County?
Yes, sir.
Thank you.
The next slide will show the notification summary. The notice of violation was sent on 5/9/2024 to Jackson Residential Land Trust, number 406. It came back, it was returned to us.
Right.
So the property was posted in accordance with Florida Statute 162-12 notices and the required posting at City Hall on 5/9/2024. Notice of hearing was sent 8/15/2024 to Jackson Residential Land Trust, and the property was posted in accordance with Florida Statute 162.12 notices and the required posting at City Hall on 8/15/2024, the same day. This is, if you go to your next slide, this is the property in question. Next slide. On 11/9/2023, a patrol of the city revealed a damaged parking lot. Contact with the management company was made and they said they would look into it. On 1/12/2024, Officer Robinson spoke with a representative about the parking area and that it needed to be repaired or completely repaved. She advised she would speak with the owners and inform them. 1/22/2024, the violation had remained and no permit had been obtained. On 3/13/2024, a courtesy letter was sent. 4/5/2024, check of USPS tracking found the letter had not been delivered. The property was posted with the courtesy letter. 5/6/2024, no permits had been applied for, and the parking area remained in violation. 5/9/2024, a notice of violation was sent to the property owner. On 5/22/2024, I'm sorry, the next slide. On 5/22/2024, the notice of violation was returned as unclaimed. The property was posted. 6/19/2024, Officer Robinson conducted a site visit and observed half the driveway had been patched and sealed. However, the remainder, which is the worst condition, remained in violation. 6/21/2024, Officer Robinson left the employment of the city and the code enforcement manager took over the case. On 6/26/2024, I conducted a site visit and observed the parking area was still in violation. Today, I conducted another site visit and the parking area, is still in violation. Next slide. This is a photograph that was taken in November of 2023. You can see in the large portion of the parking area actually missing. Here's just another angle of it. You can see the brown building to your left, that is 406.
And do you know where the property line begins or ends here?
It goes pretty much right down between those two fences. If you're on, are you on the?
Yeah, and I'm looking at the second photograph here. There are two poles.
Yes.
That are visible.
Yes.
So I assume one of those poles is the property line.
Yes, the left pole is, I would imagine, would be your property line, if
Okay.
not right down the middle of those two poles.
Okay.
Next photograph shows the area, the left side of the parking area to be paved. Actually, it wasn't paved. They used cold patch on it, and then they sealed it after that.
And did that meet was that to the city's satisfaction?
They can use cold patch. We discourage the use because it will not last, and they will eventually be replacing it later on. However, if they did go through with cold patch and put that on there and then sealed it, it would meet the code. They would, because these are technically potholes, so it would, we would find them in compliance, but probably in a year they would be in violation again. So
okay.
We discourage the practice. Here's another angle. This is in June of this year. As you can see, they've done a portion of it. They haven't done any more to it.
I assume because they're not accepting the city's mail, that there's been no contact with the owners, or I guess the management company also, as to why'd you only patch half of it? Why don't you do the whole thing or anything like that?
Yes, I'll explain that.
Okay,
in
all right.
a second. I'll give you a little bit more background in a minute.
All right.
This is just another angle on June 26th, just showing that only half of it was corrected. And that's today. As you can see, it's still in the exact same condition that it's been in since June.
Yeah.
And the next photo, just another close-up of it. I wanted to make sure I got everything on it. The next photo shows just a wide angle. This is the one with the red car in the picture.
Is that a tenant's car, do we suspect?
More than likely, yes.
Okay.
You can see there's 2 units in 406, and you can see the parking stops. There's 2 on the right, 2 on the left. The 2 on the right say a 1 on it, and the 2 on the left have a 2 on it. So that actually, once again, denotes that it goes to 406. And you'll understand why I said that here in a minute. And then the next photo, I think, is my last one, and it just shows the other half.
Let me just make sure I'm understanding here. So
Sure.
406 is on the left. This is apparently a duplex?
Yes, sir.
And the
Can I approach real quick?
I'm sorry?
Can I approach real quick?
Yes, you may. And is the ownership is of both sides of this building and then includes the area that it's not patched?
Yes, sir. The entrances are here on the left side of this 406 of this building here. And then you have unit 1 and unit 2. And then you have 1 here and then 2 here. They both have 2 parking spaces apiece.
Right, and so 406 is the address for the entire building. It's not like they can claim, oh, we only did half of it because the other half is 407 or some such nonsense.
Yes, sir. That's why I was making sure that you saw that.
I got it.
And the 1 and the 2 and everything.
Okay.
The owner or an individual on an unknown date contacted the permit tech.
Okay.
And informed the permit tech that she didn't understand why there was a posting because they had fixed the parking lot. She was informed at that time that they only fixed half of the parking lot, and she said, well, no, that's the whole parking lot. And we said, no, that's not the whole parking lot. So it kind of went back and forth on it. So we told her to contact the property owner and inform them that they only did half of the parking lot per the Brevard County property appraisers.
Yeah.
You can see clearly that that whole area is your parking area, and and it also denotes, we also said, it denotes on the parking stops, unit 1 and unit 2. The owner's not receiving the letters through the USPS due to the fact that the address in Brevard County property appraisers is a storage area in, I want to say Melbourne. I can look it up for you real quick. Yes, in Melbourne, off of North Wickham. It's actually a storage facility. It's not, there's nobody there actively every day, so.
So basically, the owners have given the property appraiser a mailing address that they themselves are unable to access mail from.
Yes, I'm not sure, they may get mail there, but they're of course not going to sign for a registered mail.
Certainly not.
They would, they would leave a sticker or whatever saying, hey, you have mail, and then you have to come and get it.
Yeah.
Now, every time we post the property, the notices have been removed.
Okay.
And we have had contact with the management company, and then this lady who called anonymously, I guess, to permit tech. She just relayed it to me. She said she didn't get a name or anything. This is just what she said.
So the person who called the permit tech did so anonymously. But the person just wouldn't give their name, or just we just don't have a record of the name?
We don't have record of it.
Okay.
I believe that the individual said, I'm calling in reference to 406 Jackson.
Okay.
And it was relayed to the permit tech that the owner has fixed the parking area. They came back to me and I said, no, the parking area is only half fixed. They went back up and explained to the lady, and then she just boop, hung up.
Hung up. Okay. All right. Anything further?
That's it.
And since we don't have anyone to represent the owner here, or the management company representing the owner, do you have any recommendation as to how long they should be given to fix the other half? And
Yes, sir.
also in terms of how much of a fine that, well, actually, the fines will be determined if they don't get it fixed.
Yes, sir.
Okay.
And on your last sheet there, it's
there.
the recommendation, based on the testimony and evidence submitted at this hearing, staff respectfully requests the magistrate find the respondent in violation of notice of violation and give the respondent until September 24th to come into compliance with the notice of violation and have compliance confirmed by the code officer. Now, September 24th is the next meeting.
Okay.
If you would like to give them the week before or what have you, it would actually have to be 2 weeks before to be able to get them in.
We have Labor Day in the middle. I'm going to give them a fair opportunity to get this thing fixed, and I suspect they will not, based on past performance. But we're going to bend over and be fair here to
That's
give
fine.
them
Then you'll hear
chance.
this again in October.
In October.
If they don't.
I have a suspicion we will be back about this in October. Very good. I'm prepared to rule on this. I find that the respondent, Jackson Residential Land Trust, is the owner of the subject property. I would note that inspections were conducted on November 9th, November 22nd, 2023, that a courtesy letter about the violations was given on March 13, 2024. Additional inspections were made by Officer Palmer on June 26, 2024, and then August 27th, which is today, yes, 2024, that the notice of violation was first served by certified mail on May 9th, 2024. It was returned unclaimed. Then on May 22nd, 2024, the notice of violation was posted at the subject property and at City Hall. The notice of violation gave the respondent 30 days to make the correction, which I find is reasonable. The violations were not corrected. A notice of hearing was served by certified mail on August 15, 2024 by posting. The attempt at certified mail, which we presume was not received, however, was posted in accordance with the law at the subject property and at City Hall. An unnamed individual did contact a permit tech of the city who informed the individual that the property was the driveway there, or parking lot. Should we call it a parking lot or driveway?
I was calling it the parking area.
The parking area. The parking area, I like that, was only half repaired. I find that the city served the notice of violations, the notice of hearing in compliance with city code and Florida statutes. I find the respondent is in violation of section 34-96 pertaining to maintenance and upkeep for all improvements in the city, and to keep the exteriors of properties in the city in a clean, sanitary, and safe condition. I do not find, and also that they should be maintained in safe repair, capable of performing the function for which the feature was designed or intended. I find all that to have be in violation. Exterior properties must be kept free of all nuisances and conditions which may create a health hazard. I'm concerned that someone could trip on this uneven potholed asphalt. I find there to be a trip hazard and a violation of public safety. I find additionally a violation of 34-97 subparagraphs A3 of the city code, which imposes a duty on every owner of every commercial or multiple family dwelling in the city to maintain the premises free of hazards, including holes, breaks, which shall be filled and repaired where necessary to eliminate hazards with reasonable dispatch upon their discovery. These respondents have had more than reasonable dispatch after discovery. I'm ordering the respondents to come into compliance by acquiring all necessary permits, repairing all potholes and missing asphalt in the parking area of the subject property by no later than September 24th, 2024, and to have their compliance confirmed by the code officer. If there's a failure to timely comply and correct the violations, I would instruct the code officer to schedule a hearing before me for the imposition of fines pursuant to the Massey case, in which case fines may be entered up to $250 per day per violation, and that any fines that I may impose may become a lien in favor of the city on the subject property as well as on any other real or personal property of the respondent pursuant to the city code. And I will put all that in writing, and I'll endeavor to get that to the city tomorrow. Is there any other business this evening?
That's it, sir.
We'll,
Easy.
very easy. We'll adjourn it. Thank you very much.
Thank you, sir.